Good morning, good afternoon, good evening, depending on where you are. Welcome to Mayor Brown's webinar on China's Unreliable Entities List. My name is Tamer Solomon. I'm a partner in the Washington, D.C. office of Mayor Brown, partner in the Government and Global Trade Group, and head of our export control and economic sanctions practice. Joining me today are several of our partners, Jing Zhang, who is a partner in our Government and Global Trade practice. Jing spends a substantial amount of her time between Washington and Beijing and focuses on trade disputes as well as trade compliance and regulatory matters. Andrew Olmem, a partner in our public policy practice, recently joined us from the White House, where he served most recently as Deputy Assistant to the President for Economic Policy and Deputy Director of the National Economic Council. Yoshi Ito is a partner of the Government and Global Trade practice, focusing on export control, sanctions, and other trade regulatory matters, and a leader of the firm's Japan client team. And last but not least, Nikolai Mizulin is a partner in the Government Global Trade practice. He joins us from Brussels, where he heads our international trade practice in Brussels. There is a lot of attention to the new unreliable entities list that has recently been announced by China, and a lot of speculation about what it might mean. We'd like to use our time today to unpack what is known from what is not, separate fact from rumor, and consider practical suggestions for what companies can do at this stage. Jing and Andrew, let me start with you both. I'd like to start with you because it's important to understand the broader context in which China has introduced the Unreliable Entities List framework. Jing, beginning with you, you've been closely watching the evolution of China's emerging export control regime, as well as the escalating series of trade and national security restrictions between the U.S. and China. It seems we're seeing headlines every few days involving those tensions. And some of those have involved the addition of Chinese entities in a variety of sectors to U.S. export control and sanctions lists that restrict their ability to obtain goods and technology from the United States. Before we get into the specifics of the Unreliable Entities List, can you just generally give us a brief overview of the context, what the list is, and how much this is a reaction to the designation of Chinese entities on the U.S. export control list?
Sure. Thank you, Tamer. So let me start with some background and an introduction to some of the key provisions in the new regulation that was just announced by China. So by way of background, the Unreliable Entity List, UEL concept, was announced on May 31st, 2019 by MOFCOM at a press conference. Timing-wise, it is very close to when the United States designated Huawei on the entity list. There was never an official confirmation of the connection between the two actions, but I think it is pretty safe to assume that the designation of Huawei was at least one of the factors that prompted the announcements. And then during the next 16 months, a lot of things happened on the US side, including the following: designating Chinese companies, including high-profile ones, for a variety of reasons, some of which are very sensitive in the Chinese context. And then here came the US-China Phase 1 deal, which was a positive sign at the time. However, before and after that, there continued to be tightening of export controls on China. Then it was added Xinjiang-related sanctions, Hong Kong-related sanctions. There's also a Clean Network initiative and by the State Department. Now there are also two executive orders on two very well-known Chinese apps. And in actuality, this list can actually go on for quite a while. So eventually on September 19th, 2020, the provisions on the Unreliable Entity List was issued, and it took effect immediately. And here we'll just refer to it as the UEL provisions in later discussions. And under the UEL provisions, a working mechanism was established to administer the new UEL regime. It is an interagency process involving relevant departments of the central government. The term relevant departments is not defined, but it is specified that, and it's also understood that the office of the working mechanism will be at the Ministry of Commerce, MOFCOM. So MOFCOM will be the coordinator, or so to speak, the chair agency for the working mechanism. Other than MOFCOM, other agencies that are likely to be included include the National Development and Reform Commission, NDRC, the Ministry of Industry and Information Technology, MIIT, the Ministry of State Security, and et cetera, et cetera. The Ministry of Justice acted as the coordinator for this regime while it was being developed for a while. So it may have a role to play too. Other agencies may later become involved for enforcement purposes. And under the provisions, the working mechanism was actually granted a lot of power. It is authorized to initiate investigations based upon its own decision or upon suggestions and reports from the relevant parties. And based on my conversations with some of my contacts, the suggestions and reports can come from either government agencies or private parties like companies and individuals. And when a decision to initiate is made, a public announcement shall be made to the public. The working mechanism also has discretion about ratification period. This is a period within which the foreign entity that may be that has been designated will have to correct its actions and trying to avoid negative consequences. Under the provisions, it's not very clear whether there will be an appeal mechanism for challenging working mechanisms decisions, be it a initiating decision or designating decision. And by all indication, I think challenging this type of decisions, which is very likely to be national security related, is probably rare. And like in the US, the challenge is likely to be an uphill battle. Overall, I think the new regime is likely to be, at least in the short term, a very flexible regime which provides a legal basis for the Chinese government to respond to certain situations where it considers foreign entities have harmed China's national interest and some actions must be taken. The US entity list is certainly part of the concern, but it has gone much beyond at this point. The process itself will to a certain extent emphasize transparency and procedural rights, which might be good news to a lot of the multinational companies operating in China.
Thanks, Jing. Andrew, let me turn to you. You recently left the White House and had a unique vantage point on the regulatory environment that's been evolving over the last few years. And we've been seeing a lot in terms of change regarding how companies with U.S. touch points can deal with China, particularly in the last several years. I'm sure that this was often a subject of discussion. Jing just explained that although the China Ministry of Commerce just issued this framework now, it announced it originally about 16 months ago, very, very shortly after the Huawei designations. And now we're seeing the framework very shortly after the TikTok and WeChat executive orders threatening restrictions on those two companies. My question for you is, from your perspective, how much should we read into that timing? And what signal do you think it's intended to send?
Yeah, I think it's clear that the timing of and the policy are really designed to signal that China needs to respond to U.S. actions with respect to U.S. policy towards certain Chinese tech companies, and that there will be a response on China going forward. Now, I think that's been a clear message, but I think it's also important to note that it's unlikely to change U.S. policy for a couple of reasons. The first is the U.S. government's actions with respect to many of the Chinese tech companies, including Huawei, are based on long-standing grievances and long-standing national security concerns. Those concerns are not going away, and that policy with respect to those companies that's already been laid out is pretty firmly established. Second, and I think this is something that's often missed, is that U.S. policy with respect to Chinese tech companies in particular has strong bipartisan support and public support in the United States. It's interesting also to note that the Congress has passed a whole series of measures imposing additional restrictions on companies doing business with certain Chinese tech companies, in particular, again, Huawei. These actions, I think, show the breadth of the support for the U.S. policy. For example, earlier this year, the Congress imposed a restriction on any company contracting with the U.S. government that prohibits those companies from using in any material way technology from Chinese technology, a list of Chinese tech companies, including, again, Huawei, in their operations. Not only in their operations with respect to fulfilling the government contract, but anywhere in their operations, regardless of its relevance towards fulfilling the government contract. That's a pretty broad and stringent restriction, and that passed the Congress with overwhelming support. So I think to the extent that these actions by China are intended to change U.S. policy, it's very unlikely that they would do so. And therefore, if U.S. policy is not changing, I don't expect China's policy here on its unreliable entities policy backtracking anytime soon. So this will be part of the new framework that the U.S. and between U.S. and China relations going forward.
Thanks, Andrew. Jing, maybe let's drill down a little bit then. As a practical matter, what do U.S. and other foreign firms operating in China need to be thinking about right now? What are the criteria for designation on this list, and what can companies expect in terms of process?
So I think at this point, companies operating in China should pay a lot of attention to some of the details provided in the new UEL provisions. And so the criteria for designating a foreign entity as an unreliable entity is as follows. So a foreign entity which can include enterprise, other organization, or individual can be designated for either endangering China's sovereignty, security, or development interest, or alternatively, suspending normal transactions or applying discriminatory measures, which causes serious damage to Chinese entities or individuals. If these criteria are met, there are also a host of factors Chinese government will consider to determine whether an unreliable entity designation is proper or not. The first factor is degree of danger to national interest. Second one is degree of damage to a Chinese entity and individuals. Third one, compliance with internationally accepted economic and trade rules. This is, among others, an undefined term. And lastly, there's a catch-all provision. Other factors shall be considered which may be relevant. So as you can see here, a lot of the terms listed are very broad, but there's not much detail provided in the UEL provision itself. And in terms of the procedures for designating a foreign entity on the UEL, interestingly, there are two types of procedures provided in the provision. The first type is the standard procedures. It starts with the initiation of an investigation by the working mechanism, which comes with a public announcement. And then comes the investigation, which is going to run its course, during which the foreign entity at issue will be afforded the right to participate and defend itself. And also, the decision on the whether to list a foreign entity will also be announced publicly. What's really interesting about these standards procedures is that in the middle of the investigation, there's opportunity to suspend it pending discussions with the foreign entity. and after which the investigation can either be resumed or just terminated. There's another type of procedure, the expedited procedure provided in the regulations. And those procedures are reserved for cases where the Chinese authorities thinks the relevant facts are crystal clear, such that an investigation is actually not necessary. So in that case, the first public announcement will just be the decision of designation. And by every indication, I think the expedited procedures are very likely to be reserved to be applied to very small sets of cases. And what are the consequences of being designated under UEL? I think the companies operating in China should be very mindful of these quite severe consequences of a designation. It includes possibly prohibitions or restrictions on China-related import and export activities, prohibitions or restrictions on investments in China, and also prohibitions or restrictions on entry into China, which can take the form of restrictions as to individuals, restrictions as to means of transportation, also certain adverse measures related to cancellation of work permit, visa, or resident permit. If you have any familiarity with the Chinese system, work permit, visa, and residence permit are not small matters in China. There's also a possibility of administrative fine being imposed on foreign entity for being unreliable. And of course, there's also a catch-all category called necessary measures. And it's interesting to see that as compared to the 2019 announcements, some of the potential administrative actions that might have been considered in the past appears to have not made the list. And happy to discuss it offline as to the reasons. And also, there's this concept of a period of ratification, which is at the working mechanism's discretion. So when the working mechanism announces a designation against a foreign entity, it can choose to give the foreign entity a period for ratification. And during this period, all adverse measures that has been announced will be suspended, meaning during this period, there will be no consequences for being designated under UEL. And if proper corrective actions are taken to the Chinese government's satisfaction, at the end of this period, the foreign entity at issue will just be removed from the UEL, which automatically takes away of the possibility of administrative penalties. So I think those are the key details from the provision that at this point, companies operating and investing in China should pay a particular attention to.
Thank you, Jing. Yoshi, maybe let me turn to you. You spend a lot of your time working with companies in other markets who view the U.S. and China as an important and key market for their own business. One of the practical issues that executives and compliance professionals are dealing with right now is the risk of getting caught in the crossfire of trade tensions between these two markets. When I listen to what Jing just walked through, it strikes me that some of the criteria are not only broad, but go beyond what we might think of as traditional national security issues. Think concepts like endangering development interests or suspending normal transactions as being a criteria for designation on a list like this. What are some of the specific concerns that you see clients grappling with as they consider this new regime and how it might be used?
Hi, Tamara. Thank you. Based on the comments we have received thus far from non-Chinese companies, not only doing business in China, but also from those doing business with China from overseas, have a broad range of concerns. Their concerns can be categorized into three general areas. First, as already pointed out, the scope and meaning of certain key terms in the UEL provisions are quite unclear. Second, we don't really know what the intentions of the Chinese authorities are and how they will actually implement and interpret the UEL provisions in practice. And third, even if the list is not released anytime soon, the threat of becoming listed is already having some impact on economic and business activities of companies doing business in China, as well as those trading with or investing in China or Chinese companies. Let me briefly explain each of these concerns. As for the concern over the scope and meaning of key terms, the introduction of the new concept of endangering national sovereignty and development interests as a basis for becoming listed is causing anxiety among non-Chinese companies. If you look at Article 2.1, which is available, by the way, in English translation from the website, you will see that these concepts are not necessarily linked to violation of normal market principles, unlike Article 2.2, which addresses the concern over discriminatory measures in violation of such principles. So in theory, any non-Chinese company's business conduct inside or even outside of China could be potentially viewed as against China's national sovereignty or development interest. When concept of the unreliable entity list was informally announced last year, it was thought that the list would be a countermeasure to U.S. entity list. Article 2.2 appears to reflect the Chinese concern in this regard. With the introduction of national sovereignty and development interest concept, the UEL appears to be expanding the scope of application beyond the U.S. entity list, according to some observers. As for the intent and implementation practice of the UEL, the Center for Information and Security Trade Control, or CISTEC, CISDEC, which is a non-profit organization based in Japan, noted that Chinese authorities appear to be sending somewhat mixed messages. While MOFCOM officials reportedly commented at a press conference that the implementation of the UEL provisions will be done in a restrained manner, articles that appeared in the Global Times, which is known as semi-official Chinese news media, even before and after the release of the provisions, seem to be sending a stern warning in connection with the UEL, according to CISTEC. As such, CISTEC is calling for clarity and restraint in connection with the UEL. As for the impact of business or on business, because of the uncertainties and potential negative consequences of becoming included in the list, some non-Chinese companies are considering adoption of very strict compliance policies and procedures that go beyond standard legal compliance to address politically sensitive issues. As a result of such strict policies and procedures, some companies may be less inclined to make external statements with any political implications. Others may forego business opportunities that may involve sensitive issues. Some other companies may reconsider their mid to long-term business strategies, including global marketing and supply chain plans.
So Yoshi, I hear that concern with respect to the breadth of the law. I also hear, Jing saying it's flexible and therefore, there's discretion to enforce it. There's also discretion not to enforce. In practical terms, what would you recommend non-Chinese companies operating in China do at this stage to address some of the concerns that you just walked through?
Well, naturally, there's no one-size-fits-all approach to address their concerns. As although we call them non-Chinese companies, their businesses, they're involved in many different industries, types of business, nature of their business, different relating to China. Some may be operating within China, have presence in China. Some do not have anything to do in terms of physical presence in China, but then still they may be trading with Chinese companies or investing in China. As listeners are keenly aware, the UEL is only one of many measures that emerged in the context of heightening confrontation between US and China. But non-Chinese and non-US companies exploring business opportunities in both countries are significantly impacted by such measures. So it would be to their advantage to voice their concern to Chinese authorities through their own respective home government authorities with specific proposals for solutions in their respective business fields. At the same time, including carefully crafted provisions in their contract with Chinese parties may also be helpful in controlling risks associated with these measures, including the UEA.
Okay, thank you, Yoshi. Maybe let me turn this over to Nikolai. What Yoshi just walked through brings me to a different kind of practical consideration, Nikolai. We've been talking a lot about the US-China dimension to this, but the fact is the law doesn't distinguish between US and other quote-unquote foreign entities. And in fact, EU companies who've had a lot of experience lately dealing with extraterritorial application of US law are now facing the prospect of extraterritorial restrictions from both the US and China and political pressure from both jurisdictions. My question for you is, what should EU companies be thinking about at this point in time?
Yeah, thank you, Tama. I mean, there is definitely no doubt that there is a risk of designation by China as an unreliable entity for the European companies, and we already seen certain rumors or suggestions in the media that mention certain European financial institutions. Now, legally, I mean, since the timing of the announcement of the unreliable entities list appears to be linked to the restrictive regulations imposed by the US administration, as Jing has discussed, and since in reality, EU companies often choose to comply with those US regulations, there is definitely a risk that EU companies can be an equally valid target for designation as unreliable entities and to fall under the category of companies that, quote, endanger national security of China, unquote. Now, for example, in case of suspension of transactions based on extraterritorial US sanctions. And also in terms of the risks, I mean, MOFCOM also publicly indicated that the unreliable entities list, in fact, does not specifically target US companies, so for that purpose, companies from any given country, and that it, in principle, intends to apply the list in a non-discriminatory fashion. And that is certainly of concern. And in fact, just staying in a bit wider trade environment, in the context of trade litigation, what we have already seen is that China's response to the US anti-dumping practices and treating US chemical companies as non-market economy companies, apparently that has already also had a spillover effect on the treatment of the EU companies, which are purely EU-owned based and export products to China from the European Union, not from the US. So the risk is certainly real. So in practical terms, from the EU perspective and from the perspective of the European companies, what is to be done? And the first practical point is pretty straightforward, is that, I mean, going forward, EU companies' compliance programs will have to incorporate now not only EU sanctions and export control, not only US and UK disciplines in this regard, but also what is going to be extraterritorial China's export control and sanctions regulations, which include the unreliable entities list. Obviously, this is to the extent that in terms of compliance programs, this is to the extent that the EU does not in turn extend its blocking statute to the Chinese extraterritorial restrictions. You may know that the blocking statute right now is program specific. It targets specific legislation, in particular in the United States. And for the time being, there is no Chinese instruments mentioned there. And in that scenario, EU companies will certainly face another layer of complexity in terms of navigating the sanctions laws of different jurisdictions. Second, as Jing described already very well, based on the text of what China has published, it's unclear how China will treat EU companies that are seen as taking an inappropriate action vis-a-vis Chinese companies based on extraterritorial application of US laws. In particular, what's unclear right now is whether there actually may be a ground for exclusion from designation under China's regulations, based on the fact that the EU company takes action vis-a-vis Chinese counterpart based on US law. EU companies, however, must consider carefully in terms of risk assessment, the potential for divergence between US and the EU sanctions regime with regard to China, and also the legal and commercial issues that arise in this connection. And whether EU companies will actually be added in the end of the day to the list in China is also likely to depend to a large extent on whether and how, to what extent, the European Union will align its policy of restrictions vis-a-vis China with the US policy. There are certainly signs where we see convergence, for example, with regard to Hong Kong, human rights, Xinjiang, in certain member states, there are restrictions with regard to Huawei and 5G infrastructure. But prospects, to be frank, for complete alignment between US and EU on that front are far from clear. And here, one thing to bear in mind, as far as also the risk assessment is concerned, is that unlike the US, I mean, the European Union right now, as far as the legislation we have, has very limited leverage with China to defend any EU company which may end up on such a list. Because unlike in the US and the EU, we have no legislation right now in place that would allow quickly and efficiently to impose retaliation measures similar, if you take the trade field, Section 301, Section 232 in the US, or overnight designate a Chinese entity into a list, or to adopt proportionate export control restrictions. That requires further legislation at the EU level, and most importantly, requires a consensus of the 27 EU member states. And that is going to be in case of China, unlike in case of Iran, unlike in case of Russia and other countries subject to the sanctions here, very difficult to achieve. Why? Because a lot of EU member states are significantly economically dependent on China. The third point to mention is that the EU companies facing this prospect of substantial divergence between US and China regimes may look into their supply chain, and in fact may consider realignment of such supply chain in a way that will minimize risk based on their particular circumstances. What we mean to say is that to the extent supply chains can be diversified and structured in a way that can satisfy both sanctions regimes at the same time, meaning the US regime as well as China's regime. I mean, the problem of being caught between a conflict of laws, between the conflict of Chinese and US sanctions may be avoided. And finally, I mean, based on our experience with the EU blocking statute as a response to the US extraterritorial sanctions, for Chinese subsidiaries of EU entities, there are a number of lessons to learn. And those are very briefly, first of all, when you face the conflict of law situation, make sure, first of all, that there's indeed a problem. And as a starting point, consider the jurisdictional nexuses and where there is a material risk of enforcement in the two jurisdictions with conflicting laws. Second, make sure that there is indeed a conflict of laws, that you face such a situation legally, because an entity may be subject to two conflicting sets of laws, one of US and one of China, but its actions may not necessarily be covered in the end by both. For example, in the EU blocking statute, you may know it covers only some US sanctions in relation to Iran, and compliance with other provisions of US sanctions on Iran is actually legal under the EU blocking statute. And third, consider the potential ways out of the conflict if you're actually facing it. Because there may be possibilities to obtain waivers from the competent authorities, either US or in China, even though in China we do face quite a significant degree of uncertainty, or bring forward justifications for complying with a conflicting law, something that I alluded before. So all in all, the key lessons that we already learned from a conflict of laws here in Europe is that be proactive to avoid the conflicts. Samer?
Thanks, Nikolai. That's very helpful advice, and certainly the experience with managing those conflict of laws issues in the sanctions export control context is very helpful. maybe just looking ahead, let me come back to Andrew and Jing and bring this back to the broader U.S.-China context. I want to ask you both to address a couple of final questions before turning to questions from the audience. I mean, you've heard the practical concerns that that have been raised by Yoshi and Nikolai from the perspective of foreign investors in China. As I think has been said, when these measures came out, the Chinese government made a concerted effort to emphasize that these changes don't signal a more fundamental change in the investment climate. They were very keen to get the message out that they remain committed to foreign investment. While that may not take all of these issues away, it certainly does seem to be a calculated message. So Jing, I'd ask you to share your perspective on how companies should interpret that message from the Chinese government and what could they do now to minimize the risk. And Andrew, I'll ask you essentially the same question with a slightly different spin. I mean, share your perspective on that messaging from the Chinese government, but more generally, how do you see these risks evolving in the near future? So Jing, maybe you can start.
Thank you, Tamer. So I think, first of all, Chinese government is probably pretty sincere in giving out the message that went out almost simultaneously with the announcement of the UEL provisions, which consists of a press conference by a speak person for the MOFCOM and also a professor who's said to be on very good terms with the Chinese government. I think it's consistent with Chinese government's strategy now, their development goals, and over the past year, the multiple efforts it has made to make China a more sort of foreign investment friendly country. And does it mean that the foreign companies then have no concern, should not be concerned about the new unreliable entity list regime? I think the answer is also no. I would encourage companies to think about like two questions in this regard. First, what will be at stake politically if in the medium term, no action whatsoever is taken under this brand new regime? Second of all, I would encourage you to think where the public sentiment is right now in China. And by public sentiment, I don't mean what's being said on some semi-official newspapers. I think what foreign companies, multinationals doing business in China or operating in China should more carefully watch for is the attitudes held by certain mid to senior level officials right below the ministers, how they are seeing these issues. And many people, especially in some large cities in China, who have actually worked in the US or other Western countries for multiple years, and what they are thinking about these issues. I think right now there's a very legitimate concern in China that if the Chinese government takes any official action against any foreign company, the actual scope of damage will go well beyond the official action. So I think that's the concern. And I also think companies are at different levels of risk under this new regime. And for companies that are, so to speak, higher risk under the new regime, I would encourage you to just look at the provisions in the UEL regulation and just look at how many opportunities they have afforded you to engage with the Chinese government. The investigation itself can be suspended. There's also a possibility of ratification period. So most likely there will be some compromise out there for you to reach. And for other companies, I think you should also take UEL very seriously because remember the suggestion and reports can come from private parties. And I'll also remind you that before the announcement on public announcement on initiation, the process will remain non-public, which may not be a bad thing, which means if the Chinese government gets a report, there may be a call to the foreign entity at issue. So I think that first context that the foreign entity gets with the Chinese government will be very important. And I think it's totally fine to share certain concerns, but I also hold more reason to be careful and be specific in your concerns. And I would recommend focusing on practical issues that the Chinese government may actually help you solve. I think overall, it is good to keep in mind that it is extremely unlikely the Chinese government is on some sort of like warpath against foreign companies. And so it's a matter, I think it's key right now for foreign companies concerned with the UEL regime, just to have a very coherent narrative and strategy that you can comfortably defend in multiple jurisdictions. And I actually believe high quality legal advice should be part of it. As Nikolai mentioned, if you say there's a conflict of law, I think generally if you have strong support while drafted legal opinion to support that, that goes a long way to show your sort of sincerity in complying with laws with all jurisdictions. And also, if you go beyond a little bit, there's better to be sort of well-documented legal advice for justifications about whatever specific concern you harbor, so that you have to sort of go beyond a little bit, or like somewhat beyond the black letter law of whatever jurisdiction you are concerned about. So that's my overall comments to this question.
Yeah, let me follow up on that, because I agree with that analysis. And what I'd add to it is that I think companies need to be very cautious and think through their interactions in this space. You know, companies that have significant operations both in the United States and in China, or are looking at expanding in either of those jurisdictions, need to think through carefully their plans here, particularly in the industries that are particular focus for policy here, namely the technology companies. I think the real risk kind of going forward is kind of a continued escalation. And once kind of companies have made a decision to expand their operations or continue operations in both jurisdictions, being caught between both countries. You know, you've generally seen U.S. policy, although at times it seems like it's proactive, and these new measures, as we talked about, that have come out in the last couple of months. In many respects, they are more reactive to Chinese behavior. You know, we've seen with respect to Hong Kong, certain human rights issues, you know, that has triggered a reaction from the U.S. Congress, as I was mentioning earlier, kind of the U.S. population, and also other countries that have tended to result in additional U.S. actions. So you always have to be conscious about kind of where future policy can go. And right now, you know, I don't see a dramatic escalation in the state of the relationship. You know, it's also important to remember is that even though the administration has taken these actions with respect to Chinese tech companies over the summer, it's also in the process of working with China to implement the phase one trade deal, and making sure that those mutual gains for both countries from that trade deal are finally implemented. So there's a dual policy by both governments going on, and so that one has to carefully navigate. So I think this is certainly a fluid area. It's one where caution, and I also agree with Jen about proper counsel and coming up with a strategic plan on how to think about these issues, to make sure that one doesn't inadvertently get caught in policies between the two. You know, once you're caught in kind of that unique space where both countries have a particular interest in your operations or your activities, you know, it can quickly become a larger media event, a larger issue for the company. So it's very important to be proactive and think about these issues before they're a problem.
That's really good advice, Andrew. And certainly we have seen companies inadvertently falling into that trap, and it's really easy to become a political football. And I guess one of the takeaways from what I hear you and Jing saying in some sense is maybe thinking broadly about not just the legal issues, but also sort of the government affairs issues, communication strategies. And a lot of times you might have a company that, you know, it's quite sensitive to the issues within China, but maybe other parts of the organization, there may be statements that get out from headquarters that may be problematic. So you might want to comment on that.
Yeah, I actually think one of the real risks and type of company that you can run into problems are new companies that are very innovative. You see this in the tech space a fair amount, where the technological developments are so kind of exciting and promising from a business perspective, and the technical accomplishments are what the executives are focused on, that you lose sight of the fact that when you start to deploy this new technology, that you've got to think about the larger legal and geopolitical issues that may be created by that new product. You know, a company may think, well, here's a new product, consumers are really going to love it, and haven't thought about, well, wait a minute, what are the national security implications for this? You know, will this trigger attention for legitimate national security concerns? You know, those are things that are also, again, with new companies, entrepreneurial companies, that are just inadvertent and not, not intentional. It's just not part of the culture of the company, and that's really where you can see problems coming up.
You mentioned, just a quick follow-up. I mean, you mentioned progress on trade negotiations. To what extent do you see the underlying issues here going away, to the extent that there's substantial progress, or sustaining?
I think there's always a chance for improvement, and I think we saw when the Chinese engaged on the phase 1 deal, there was definitely a thawing of the relationship, and that was good. You know, now that it's stalled, and in the wake of everything that's happened over this summer, you know, certainly the tensions on technology issues have really grown. So, you know, again, I do think a lot of this is how the Chinese react to some of these larger issues. Hong Kong, in particular, has been a real catalyst for U.S. actions. Congress is very focused on that. So it'll be a very, going forward, I think, very event-driven on how particularly the Chinese government reacts to some of these events going forward.
Okay. Well, oh, sorry, Jing, do you want to comment on that?
Yeah, sure. I think it's very good comments from Andrew. And I think I just want to add it a little bit from the Chinese perspective. I think it's very likely that this issue for a while was give China some indication that there may be a opportunity to sort of use it to really improve the Chinese image and also bettering the relationship from a broader perspective. I think the intention is still there, but I think there's a growing appreciation on the Chinese side that some of the issues that goes well beyond sort of the economic scope will unlikely to be affected to a very significant extent by the development on the economic side. But I think they have generally come to the conclusion that despite of all these, economic engagements is good. So this trade one deal is pretty much a very important, somewhat stabilizing force in a very unstable, so to speak, bilateral relationship. I think for the time being, it's still going to be a very important piece in China's strategy towards the U.S.-China relationship, and also probably being used as a way to sort of deepen some economic reforms in China, which actually help them create a positive narrative in the domestic market and also before the domestic constituents.
Thank you, Jing. We have a little bit of time left, so let me turn to some of the questions that we've gotten from the audience. You know, there are a couple of questions actually relating to the possible reach of this law jurisdictionally. One is, are foreign entity subsidiaries in China covered by considered foreign entities? I think Yoshi addressed that, but just so we're all on the same page, perhaps one of you could address that. And the other is, you know, to what extent, it's an interesting question, to what extent do we have to worry about a company being named on the list based on activities that occur outside of China, as long as it has a presence in China? So, for example, if there are statements or actions that that could trigger this law, but they're occurring outside of China, perhaps with a Chinese company engaged in commerce outside of China. Is that an issue, or does the event have to occur in China?
So I will take the first attempt at addressing these questions and turn over to others. Yeah. I think regarding the first question, the Chinese subsidiaries of foreign entities, I think you can sort of like, by analogy, looking at the definitions in the new draft export control law, which, by the way, is likely to come up, sort of be enacted this year. And I think generally, if you are a company, like subsidiary is separately incorporated in China, it is less likely it will be considered foreign. And if it is a branch office, which doesn't have a legal entity status in China, it's hard to say. I don't think has been any clear message on how sort of like a branch offices or representative offices should be treated as either foreign or domestic under these like new regimes, such as the export control regime and this unreliable entity list regime. So that's the answer to the first question. As to the second question, the UEL provisions has an article that says the working mechanism has the discretion to issue alert about doing business with entities on the UEL, and that's discretionary, not mandatory. But I would still encourage you to think about my comments about public sentiment. Again, I think there's a very legitimate concern about what kind of reaction that the Chinese public will have if the Chinese government takes a public action against one foreign company. And I will also sort of like encourage you to think about this from a broader sort of messaging perspective. Right now, this type of actions or developments is highly sensitive in China. Let's assume a UEL designation is issued on a foreign entity, and soon enough, a lot of the Chinese companies, high-profile ones, like came out supporting it and just taking all sorts of actions and trying to sort of issuing a consistent message with the government. And a lot of the sort of like foreign companies, major companies are staying silent. It's not going to land you on the highline of Chinese newspapers. I think it's possible. Is it going to be the end of the day? Probably no. At that point, I think if you have a sort of like well-prepared strategy to deal with that, it's probably going to go a long way towards achieving your goals under this sort of very challenging environment.
Thank you, Jing. And I'll offer one thought, and maybe Andrew or others would like to comment. It seems to me that if I could analogize to some of the U.S. secondary sanctions and other sanctions regimes, one of the complexities that's introduced is that there is a lot of discretion. But there's also an opportunity for discretion not to take very significant actions. And it seems like this law also, there's a lot of discretion with respect to the consequences. And I think that bakes in the opportunity for the government to make decisions about consequences for its own economic interests, right? And Andrew, maybe you'd want to comment on that.
Yeah, I think that's one of the pieces that mitigates some of the potential risks here is that in both countries, they have the policymakers, frontline policymakers are very conscious of those issues and are very deliberate in their actions. You know, the U.S. Treasury Department is very well regarded in these areas, very deliberate. You know, they've also been in this administration very key to helping move along the phase 1 trade deal. So on the kind of that path and making sure those negotiations move along, they've been engaged, and so they can take a broader view of the overall relationship, and also just from a technical perspective, they're very competent, and that reduces the risks of unintentional problems. And it also means that for companies who might have an issue, engagement here can potentially be a proactive engagement in certain circumstances can be an effective means for mitigating risks and working with the Treasury Department to make sure to address any issues proactively.
Yeah, and I think that, you know, although we don't know yet with this law, it seems that some of the signaling from the Chinese government, you know, has some of that behind it. I don't think that the Chinese government is interested in shooting itself in the foot economically with respect to decisions it makes on any company that it puts on that list. So you may have a decision not to put somebody on. You may have a decision to put somebody on in a symbolic way without restrictions being particularly consequential.
Yeah, I agree with that. And that's why it's also, from a company perspective, really important to understand the issue, come up with a proactive plan on how to handle it, work with counsel to make sure that it's credible and that there are no missteps. If there's an area you're potentially moving into or engaging in activity that may create attention by either government.
And I think we have time for maybe one last question. And again, we're happy to follow up on questions that we don't get to here. You know, this probably gets at the heart of a lot of this from a practical perspective. The question is, you know, to what extent would there be an affirmative defense for something like compulsion by law, or put more simply, even compliance with foreign law? And I think that touches on some of what Nikolai was talking about. It touches on, you know, is there greater risk if I'm going beyond the letter of the law? Is there space for me here to go beyond the letter of the law, as long as it's justifiable from a risk perspective? And I'll open that up to anybody who wants to address that.
So I will start again. So I think from last year, there's some self-message, maybe from the Chinese government, indicating that at very least taking actions strictly to compliance with export control and other laws of other jurisdictions will be taken into account when the Chinese government examines whether a unreliable entity designation is proper. And I think there's unlikely to be an official position taking on that, but I think for all the reasons discussed, that's probably a very likely position that even sort of unofficially sort of taken by the Chinese authority in the short term. And I think definitely that's a encouraging sign. And I will just really emphasize, I think the real challenging for a lot of companies is a lot of default rules that companies have grown sort of very comfortable with over the years, if like strictly followed, may lead to certain sort of positions that may cause trouble under this challenging environment, especially in the Chinese context. I do believe certain adjustments is necessary, but I think still like the bottom line is if you are careful and really sort of be sincere in just complying with laws of all jurisdictions, you are most likely doing fine, and even under the current very challenging environment.
Okay. Unless anybody has anything else, Nikolai or others, we are coming up on the top of the hour, and so I think that's a good note to close on. That concludes the webinar today. We hope that the information that we've shared with you today was useful, and appreciate your participation. Our team is happy to have any follow-ups and look forward to seeing you again in our next session. Thanks very much.